Hello and welcome everybody to the Indian Youth Economic Association's session on civil procedure and the law and execution of decrees. Today we have with us a senior advocate, Mr. S.P. Kalra. Though he requires no introduction to those who are students of law or members of the bar, for all of our other mentees joining in today, Mr. Kalra enrolled at the bar in 1963 and was designated as a senior advocate in 2002. He's a practice of over 57 years. That puts, if you were to put together many of our ages combined, if 2 or 3 of us were to sort of sit together, even our ages combined wouldn't match up to the number of years he's had at the bar. And the topic that he will be discussing today is execution of decrees. Very often it is said that getting a decree under law by a court in a certain legal suit is less than half the battle won. Especially in the legal system that we have in India, getting a decree by itself is no victory for the litigant. And indeed, execution proceedings are a necessity in almost all matters, whether recovery or property or otherwise, to get the necessary relief to the party, the more tangible relief. And to discuss this very pertinent issue, which is not only important from an academic point of view, but most importantly from a practical point of view, for those of you who wish to pursue a legal career. We have with us Mr. Kalra, senior advocate, who will be discussing this particular issue in our session today. He has a wide experience through bar. He has argued a variety of matters, and his specialty is civil laws, property-related matters, and real estate laws. He's been a standing counsel for various panels, including but not limited to, for over 16 years, the DDA and AIDS. A very warm welcome to you, sir.
Thank you. Thank you.
Yes. Yes. And now I'll hand it over to Mr. Kalra to take forward.
Welcome to all. I was thinking aloud as to why did I choose this topic of execution. As my friend pointed out, that normally after successful litigation, everybody ordinarily has an impression that he's very close to the situation where he can reap the benefits of the decree or award made in his favor by the court. But things in practice are just the other way about. No doubt it is true that litigation by itself takes very long, and it's a matter commonly known to everyone that litigation in our country, particularly civil litigation, it takes very, very long. It takes very long. Now, I will just give you a brief resume of how the litigation starts and how many stages do the stages come during the course of trial, ultimately ending in a final conclusion whereby lucky litigant succeeds and he gets the decree in his favor. Now, whenever a wrong is done to anyone, and it's a civil wrong, whether contractual or otherwise, in every case, you have to approach the civil court for relief, whatever relief in law you are entitled to. Now, the proceedings in a civil court start by institution of a suit. You commence a suit in a civil court, and by presentation of a plaint. The plaint is a document wherein you state your cause of action, you give the reason as to why you are entitled to a relief, and a complete pleadings as per law. Of course, procedure is prescribed, form is prescribed. Now all these facts are given in the pleading in plate, and by presentation of plaint to a court, the suit commences. The court takes cognizance of the suit, sends notice to the opposite side. The defendants appear. They file their own response to the plate, dealing with each allegations and contesting the claim of the plaintiff, and ultimately, after giving a complete opportunity to the parties by letting the parties produce evidence, produce documents, oral witnesses, and things of that kind, a final stage is reached where the court delivers a judgment. Now, luckily, if the plaintiff is lucky and succeeds in the litigation, obviously, he gets a decree in his favor. Court grants him the reliefs he has prayed for, or whether prayed for lesser or otherwise. So the decree is passed in favor of the plaintiff. Now the question is, now the second stage is that this decree is challengeable by way of appeals to the higher courts. First appeal, second appeal, though there are limitations as to how first appeal will be filed, what will be dealt with in the first appeal, and how will the second appeal be dealt with. Apart from these limitations, second appeal, for instance, can be dealt with by the court only on a substantial question of law, whereas the first appeal deals with all questions of fact and law, and is said to be a continuation of the original suit. Now the point is, if you keep on succeeding everywhere and you go on getting your decree confirmed, at last stage would be that anyone who is aggrieved can approach the Supreme Court under Article 136. And I'm assuming, for the sake of arguments, that everywhere the plaintiff succeeds and he gets a decree initially and gets it confirmed by all the appellate courts thereafter. Now, I'm sure everyone feels that this is an occasion for celebration. I have, after all, succeeded, and I'm sure all these successes which the plaintiff gets, it takes pretty long. It may be decades. It may be more than at least more than 1 decade. It does take. And I'm sorry, in my career as a lawyer, I've seen that there are several cases which I've dealt with, and wherein the litigation took more than 2 decades, more than 3 decades by the original court to deal with that issue. But assuming that in a reasonable time, the plaintiff is lucky enough to get the decree initially and later get it confirmed by the higher courts, Now the question is, the litigant feels now he is very close to achieving the object for which he filed the suit. I wish it were so. But I'm sorry, there is another round of litigation which is awaiting the plaintiff in the form of execution, because at the stage of execution, the judgment debtor against whom the decree has been passed, he or his representatives, they will make every possible effort to defeat the claim of the decree holder, to make sure that he doesn't reap the benefits of the decree, one obstacle after another, and each disputed fact of law or fact will have to be decided by the executive court. It will go on getting decided. Favorable to the decree holder, very well. Against the decree holder, then the decree holder will have to go in appeal. against the other side will go in appeal. Several orders passed by the executive court, are appealable orders, and therefore it, according to me, if not the same amount of time which the original suit has taken for disposal, it nonetheless it will take a little, it might take a little less, but it takes very long, even in executions, to be able to get a final judgment. Now, I will just briefly deal that after the court has passed the judgment. Now, the first stage is where the plaintiff's counsel has to be really very vigilant. That is, that you are before the right court. Now, the court which has the absolute jurisdiction to deal with the issue which you have raised in the form of claim. Suppose, God forbid, for any reason, the court didn't have jurisdiction, or there was a lack of inherent jurisdiction in court, and the court dealt with the issue and passed a decree in your favor by consent or otherwise, then as soon as that decree is put in execution, the question immediately will be raised by the opposite side that the decree has been passed by a court which lacked jurisdiction and therefore it is inexecutable. And now that question begins to be examined by the executive court. Now I give you one example. See, in consent decrees, particularly in consent decrees, suits are pending, parties come to a settlement, and that settlement is filed before the court. That in this provision is Order 23, Rule 1. You file a settlement before the court, and though court is expected to examine whether the agreement is a legally survivable document, but the court usually accepts because the parties have agreed, and whatever terms the parties have agreed to, court accepts those terms and passes a decree in terms of the settlement between the parties. Now, the question is, now there are certain specific jurisdictions for. Now I'll give you one example. In a rental litigation, the rent controllers under the Rent Control Act, which is applicable in Delhi, rent controllers have been given jurisdiction to pass an eviction order against a tenant only provided if one or the other ground of eviction exists on facts. So in a normal case, the court is expected to, after giving the opportunity to the parties, the court is expected to examine whether a ground for eviction has or has not been made out. If the court takes the view that the ground of eviction has been made out, then the court is entitled to pass an eviction order, but not without recording a finding to this effect. Now, what happens normally is, in cases where a settlement is arrived at, so the landlord, tenant, they come to a settlement. Tenant says, very well, you give me 4 years' time, 5 years' time, whereafter I will vacate the premises and hand over vacant possession to you. Parties before the court make an application in writing under Order 23, Rule 1. Court accepts the settlement and passes a decree in terms of the settlement. Now, after 5 years, the period, the time which the landlord agreed to grant to the tenant, the tenant doesn't vacate. The landlord takes out execution. He files an execution application before the rent controller and says that he should be thrown out, he should be evicted, and the vacant possession should be handed over to me. No, at that stage, if the objection is raised by the judgment debtor, which it is normally done, and it has been consistent, I'm seeing consistently this is done. So this is basically a trap. Now, takes the objection that the court never recorded any finding that so-and-so ground for eviction exists. It was only on the basis of a settlement. And settlement by itself does not confer any jurisdiction on the rate controller to pass any order of eviction. So therefore, at that stage, in the executive court, though the executive court is the same court, executive court will hold, yes, I had no jurisdiction to pass a decree of eviction, and therefore it is inexecutable. So after having spent so many years earlier in litigation and thereafter on settlement, etc., you are again at point zero, because then you again have to start the litigation, and your earlier litigation is put a knot to zero. Similarly, there are other statutes, for instance, matrimonial litigation. There are where the statute, special statute, provides for some basis for the court to hold that basis exists before the court makes any final order. And without recording that finding, if the court on its own or on consent of the parties passes an order, the decree holder, though he gets the decree in his favor, but later on he'll find it extremely difficult. He will not be able to execute it. So he won't be able to reap the benefits of the litigation which he initiated for the purpose of seeking certain relief. So therefore, the first point which I wanted to tell you was that in execution, before the execution stage arrives, and when the original litigation is going on, whatever be the stage, whether by the initial court, original jurisdiction, or by the appellate courts, the plaintiff's counsel must make sure that the requirement of law, which under any special statute or general statute, which is required by law to be established or recorded, and a finding to that effect to be recorded by the court before any relief is granted, that finding must be ensured to have been recorded by the court before the court passes any order in your favor. Because one should not make any hurry, one should make sure that the requirements of law are met. Otherwise, despite getting a decree in your favor, ultimately you will achieve nothing. Now, this is where the inherent jurisdiction problem is there. See, now, I assume for a moment that decree passed by the court and eventually confirmed in appeals, etc., is a legally valid decree passed by a court with jurisdiction, having jurisdiction to pass it. And now, after that arduous period spent on trial, the decree holder takes out execution. Now, what is it? Now, there are several kinds of decrees, various kinds of decrees. It can be a money decree. There is a suit where the plaintiff wants to recover some money from the opposite side. It may be rent due, it may be money lent and not paid. So in all these cases, ultimately the court will pass a decree for a certain sum of money in your favor, and ascertained amount, because there are several cases where the ascertainment of amount due, even the plaintiff doesn't know, because when you suppose now there is an agent, I keep on giving money to him to spend that money on a certain cause. After having given that money to him, after some time I ask for accounts. He doesn't give me any accounts. He doesn't tell me where has the money been spent. So I filed a suit for accounts against him. Now, in a case of this kind, the court will initially pass a preliminary decree directing the accounts to be taken by appointing a local commissioner or some other person or receiver. She, for a dividend direction, to have the accounts from the agent. Then after taking the accounts, taking all facts and figures as to what has been spent for the purpose for which it was given, ultimately the commissioner will record a finding that so and so amount is determined to be due from the defendant, and that eventually will be accepted by the court, of course, after giving opportunity to all the parties concerned, and that ascertained sum, fixed amount, court will ultimately pass a final decree that so and so amount is due to the plaintiff and against the defendant, and the defendant is liable to pay the same with or without interest, etc. Now, a money decree, apart from money decree, there could be a decree for delivery of a specific movable property. There could be a decree for specific performance of a contract. There could be a decree for sale of a mortgage property and recovery of the mortgage debt, etc. Now, all these cases, different methods are adopted after filing an application for execution, for attachment, or for attachment of the property, or after attachment, sale of the property, money decree, etc. So now I'm going to give you a few examples in dealing with all these provisions, which says that at each stage, an obstacle will be put forth by the judgment debtor, and that will have to be dealt with and decided by the executive court. Now, in a money decree, for instance, you have to, now as a decree holder, you have to give the particulars of the properties, money, shares, any and every movable or immovable property possessed by the judgment debtor, by the sale of which the decree holder wants to recover the money due to the decree holder. Now you have given a list. Now that list of properties, you tell the executive court that you want initially movable property to be sold, immovable property to be sold, depending upon the decreed amount. If the amount is very large and then the immovable properties are there, then those properties will have to be sold. Now, with this process, as the court will have to initially start with attachment. Court has to direct, if movable property, then the court will direct that the so-and-so movable property, particulars whereof have been given by the decree holder, in possession of the judgment debtor, should be attached. Now this attachment is to take place. The court will appoint an officer. That officer will go to the judgment debtor's house. Now that property, movable property, the officer will take possession of that movable property, keep it with him in custody. If it's perishable, give it to another custodian for custody, so as the property is kept safe. Ultimately, it is approximately brought before the court, and the property should be sold, and the sale proceeds, sold by depositing in court or otherwise, sale proceeds should be paid. Now at each stage, now for instance, there are 20 movable properties which the plaintiff had given a list, the decree holder had given a list to the court. Now the judgment debtor, he makes an application to the court saying, no, none of these properties belong to me. These properties are not mine. These properties in fact belong to so-and-so. Now a controversy has been raised. Obviously, the decree holder has a right to recover money only by sale and receipt of sale proceeds, of the property of the judgment debtor. So therefore, the court must make sure that the property did in fact belong to the judgment debtor, and as soon as a dispute is raised, that dispute will have to be decided by the court. The court ultimately, again, this decision, this dispute, and decision by the executive court, this will take time. You will produce. You don't have any document with you because the property belongs to judgment debtor. The judgment debtor will produce 1, 2, 3 correct, incorrect, false, fabricated document saying, no, this is not my property. This is somebody else's property. That somebody else will appear in the court and say, no, this is my property. So this controversy and this controversy, the decision of this controversy by the executive court, although the plaintiff has already succeeded in getting a decree, this will have to be gone into by the court in detail, evidence taken and decided. Suppose the executive court decides against you on the basis of documents produced by the other side. Suppose the executive court says, no, this property really didn't belong to the judgment debtor, so that property will be released from attachment. And you are where you were. You make no progress in getting the benefits of your decree. Similarly, in the case of immovable properties, now several false transactions are created because law is if during the pendency of a suit, if the defendant makes any transfer of any property, which is the subject matter of the suit, then ultimately the transferee will be bound by the result of the litigation. But in execution, it's only after attachment. If it is an immovable property, the court has directed the attachment. Now, after attachment, if the judgment debtor transfers that property to somebody else, then that property may still be available for sale in execution of the decree, so that the decree holder gets the money. But the point is, if before attachment he does, attachment hasn't taken place, you have applied, because after all, you have to make an application, you take time getting the settlement copy of the decree, and if you really take time, because in execution application, you are expected to act very promptly as a matter of fact. But then there are cases where the decree holder does take time in filing the applications. And under Rule 22 of Order 21, if you take more than 2 years, then even before the executive court makes any substantive order, the court will have sent a notice to the opposite side. So the notice will be necessary. So therefore, if attachment hasn't taken place and the judgment debtor transfers that property to another person, then the question precisely will be, what should happen to that property? Now that property, when the decree was obtained, did belong to the judgment debtor. And in all fairness, the decree holder expects that that property should be available to the decree holder for sale and recovery of money, etc. But since that property had already been dealt with by the judgment debtor before the attachment took place, so therefore the judgment debtor can always object to the sale of that property, and therefore there is a stage where both movable and immovable properties, there is a stage after attachment where the judgment debtor is given an opportunity to file his objections to the attachment of that property, both movable and immovable, and the court has to decide that question. Because if maybe in a given case the judgment debtor succeeds, and if he succeeds, then none of the properties of the judgment debtor remain available to the court for execution or for sale, and the decree holder gets nothing. Now this is rule, she pointed, this rule, I think this attachment of the immovable property takes place under Rule 54 of Order 281, and the objections are filed under Rule 58. Now, I wish a decree holder who has succeeded all through, who has been running around for all these years to be able to reap the fruits of a decree, he is not non-suited by the executive court, saying that yes, the objections filed by the judgment debtor are correct and the property had been transferred by the judgment debtor before attachment took place. Therefore, this property is not available. Now you find out. Now the difficulty is property of the judgment debtor, the details, etc., are hardly known to the plaintiff. Was succeeded because normally you don't keep a track of the property held by the opposite side. Though there's a provision that the court can direct, if you make an application to the court under Rule 41, the court can direct the judgment debtor to disclose his estates, to give all particulars of his property held by him. But as we know, as a matter of practice, the judgment debtor, they hardly speak the truth. They will withhold plenty of information, you won't even know about it. So therefore, this is one stage, and now this Rule 58 order, if this order is against the decree holder, then again this is the appealable. Against the judgment debtor, he has a right to file an appeal against this. Let me tell you one thing, there was a time, I think before 76, these objections used to be dealt with under Rule 58, objecting to the attachment of property, immovable property, and often, if the court held against the judgment debtor had a right to file a suit, regular suit, under Rule 63 of Order 21. He would file a regular suit, declaratory suit that this property is mine. This had been so dealt with before attachment, and therefore this property can't be made available to the executive court for sale. And that suit by itself would take, that's another suit starting in litigation. Of course, that provision has been done away with now, and that provision is not there. But it is appealable, all right. It's appealable, all right. But if the objections are straightway rejected by the executive court, I think it is under Rule 58, Sub-Rule 2, that then in that case, the judgment debtor has a right to file a suit also. So this is second stage after attachment. Now, if you cross over this stage, and property remains available to the executive court for sale, then movable properties have to be sold. Then immovable properties have to be sold by settling a sale proclamation has to be settled. In sale proclamation, again, both sides participate. The decree holder furnishes all particulars, all details. The judgment debtor files his objections to settle the sale proclamation. Because the purpose behind it is that the maximum price of the attached property should be realized, so that even judgment debtor is not put to any loss. And out of the realized proceeds by the sale, whatever is due to the plaintiff, a decree holder, that money is given to him, and the balance is given back to the judgment debtor. So sale proclamation has to be settled. Now this sale proclamation has to be settled again, and then thereafter sale has to be directed of the property. Now, after directing the sale of the property, then the property has to be auctioned. It has to be put to auction. Now, for every step in execution, there is a detailed procedure. Sale proclamation, participation by all, everyone. The judgment debtor, decree holder. Now, sale proclamation is issued, is published. Now, publishing has to be very proper. That means it has to be affixed outside the courthouse. It has to be published in the newspaper. It has to be given wide publicity so that all prospective buyers get the information that so-and-so property is on sale and we have the maximum number of buyers so that there is a competition and we get the best price. So at that stage, the publication is there. Now, property may be in your possession. If it is in your possession, you can be directed to hand over the property. You can be directed to hand over the property to the decree holder. But if the property is in possession of another one tenant or some licensee or some other person, then in that case, it's only by pronouncement of the decree at the premises, etc. But then actual possession is not given to the decree holder when the property is handed over. Now, what I find is, in execution, several orders passed by the executive court are appealable orders, and the whole process is so time consuming. Decree holder has already been exhausted by regular litigation in which he obtained the decree, initially before the trial judge, thereafter before the appellate fora, and even during the course of proceedings before the trial judge, there are several orders passed during the course of trial which are again either appealable or revisable. Or appealable orders, and nobody, because defendants, it's a matter of common knowledge that defendants are normally, invariably interested in procrastination, in delaying the proceedings, in making sure that the decree holder doesn't achieve his positivity in the matter of results. So therefore, as soon as there's an adverse order, rather I've seen in several cases, people usually make an application to get an adverse order so that it entitles you to file an appeal, and it goes to the appeal, and then before the appellate court, sometimes the appeal is taken up, sometimes the appeal is admitted and sent down for hearing. And there are cases, regular appeals, at least I can say, in High Court, appeals have been pending for decades and they have not been taken up for hearing. When the hearing starts, it may take another time, one never knows. But even the hearing has not been taken up. So I think for the time being, for today, the time is over. I was given to understand it is up to. Now, anyone interested to ask any question, so most welcome. Thank you very much.
Thank you so much, sir. It was indeed insightful. We'll wait for a minute to get some questions from our audience.
Yeah, yes. Please. So no one is interested to ask any question. Do I take it?
No, sir. I guess one could obviously be the sort of lucidity, the clarity, lecture, but at the same time, very often people take some time to type out the questions. So we'll wait a bit for that so some of the students typing questions. In the meanwhile, sir, if I could sort of pitch in, if you could shed some light on the question of res judicata in light of sort of execution proceedings, because you had mentioned 2122. The Order 21, Rule 22, and if you could shed some light in that direction.
Res judicata is dealt with under Section 11 CPC.
Yes.
Now, in 22, as you have referred to, res judicata basically applies to the suits.
Yes.
And what res judicata is, that if between the same parties, same subject matter has already been litigated between the same parties or their representatives and interest, and the court has recorded a finding thereon after giving opportunity and by recording reasons, etc., that earlier judgment operates as res judicata, meaning thereby that those parties are prohibited in law from raising the same question all over again in another litigation. That they can't do. So Rule 22, which you have pointed out, that says whether this res judicata in terms applies to execution proceedings or no. But the judgments are that the principles of res judicata do apply to the execution proceedings as well. Because if any point has been raised by any of the parties before the executive court, and the executive court has examined the issue in detail and after giving opportunity decided, then that question cannot be raised all over again in execution proceedings by any of the parties.
Yes, absolutely.
Am I clear?
Yes, I think that sort of puts things into perspective. And okay, so we have a question. I will read that out for your benefit. This question is from Sachin Salunke. He asks, why people don't use discovery and interrogation provisions in the CPC? Okay, so we're sort of moving beyond the question of execution per se, but nonetheless, if you are willing to answer this question, sir, I'll leave that to you on the question of sort of interrogatories and discoveries. Right, and this is true that very often during civil suits, these sort of aspects from civil procedure are underused, if not unused. So, would you have any comments regarding that, sir? Is it lack of knowledge, or is it lack
there are several provisions. For instance, you have referred to discoveries. Now, Order 11 refers to discoveries and issue of interrogatories, etc., etc. Now, these are the stages because the plaintiff's counsel are normally aware. See, as soon as you make an application, the court in normal routine gives a notice of that application to the opposite side. Opposite side is given a chance to file a reply. Time is taken. He takes time to file a reply. Then it's fixed for arguments. Thereafter, the court may take this view or that view. So therefore, if a lawyer appearing for the plaintiff is interested in the early disposal of the matter, somehow, which every lawyer is, every plaintiff is, so if you go on making applications, perhaps you will get nothing out of it, because I can tell you one thing: if there is a complete application of mine by the counsel for the plaintiff, number one, by the court, number two, and there are several stages, which stages, if one is able to persuade the court to resort to, most of the controversies can be resolved at a very early stage of the litigation. But provisions are there, but those provisions are dealt with in routine. For instance, as soon as you find now there's any ambiguity in the reply, now the defendant is given a chance to file the written statement. Now, written statement, he deals with each and every allegation made in the plaint. Now, while dealing with the allegations, very often he makes evasive replies, neither here nor there. Now, an example is given in one of the rules, I think it is Order 8, Rule 5. See, the example is given. I make an allegation against you that I lent you 5,000 rupees, which you have not paid, which you have not repaid. Therefore, I am entitled to recover 5,000 rupees from you. The defendant makes a response in the written statement: no, paragraph so-and-so is wrong and the right. He feels he has denied this allegation. Law says, no, this is not denied. Law says you are expected to, I say, whether you took that loan. I said I gave money loan to you, so you must first say whether you took or you didn't take loan from me, number one. If you say you took, then you say whether you have repaid or you haven't repaid. And then if you say you don't have to pay, then state before in the written statement as to why you don't have to pay when you took the money or no, and you haven't paid, then why you don't have to pay. Now, if there is a written statement of that kind, and courts are slightly indulgent because now see, there's a difficulty all around. Courts are so hard pressed. Plenty of work. One court we find in a high court, one judge dealing with 100 matters a day. Now there are 4.5 hours working hours in a day. Now you can imagine how many minutes can be spent on a case. So therefore, interrogatory discoveries, even the recording of statement by the parties under Order 10, these are all stages helpful in getting the sphere of dispute shortened to a very limited extent, so that the controversy which remains to be decided by the court is in a very sphere. But to resort to one application means your case is gone for another 2 years, So anything else here? Tax?
Okay. So I think we're getting another question from Avnish. Avnish, you raised your hand, so you can send in your question in the chat box. I think you will have that option. Nonetheless, before that, in the meanwhile, while we get Avnish's question, if you could, have you shed some light also upon the fact that an arbitral award, though it is not a decree in itself, it is to be enforced in the same way as a decree.
No. Every arbitral award, after it has been, the first stage is to the party against whom the award is to file objections under Section 34 before the court. Now, after the dismissal of objection petition, that award becomes final and is executable as a decree. It's executable as a decree. So therefore, it has to be executed the same way civil court's decree is to be executed.
That's true. Which is for our sort of law students and mentees present here, which is to be governed by the 96 Act. That's the Arbitration and Conciliation 1996 Act, and not the sort of CPC alone in that regard. So, sir, one other point that I thought that
CPC, I can tell you one thing. Practically, earlier when we joined bar, everything used to be dealt with by the civil courts. But thereafter, by amending the constitution, they created several tribunals and particular subjects were assigned to those tribunals. Now, CPC in terms perhaps applies nowhere. But there are no other principles except what are contained in CPC which are applicable. For instance, your Rent Control Act, Delhi Rent Control Act, which has been pending in Delhi since 1958. CPC in terms doesn't apply. It only applies for a limited purpose of something or to say filing of documents, etc. But then there's no other procedure for itself. Now, if you want to, you see now there is a stage for filing of documents. Now you are a plaintiff. There is a stage for filing of documents that with plaint, you must file all the documents which are in your possession and part. Now, there may be a document which is not with you, but you want to file. 10 days later, that you come by that document. Now, then there has to be another stage where you can be permitted to file that document which you got later on, and earlier you did. It wasn't with you. So therefore, for filing of documents on which the suit is based, can you imagine stage one, plaintiff file all the documents. Order 7 Rule 14 says every document which is in your possession must be filed with the plaintiff. Similarly, Order 8 Rule 1A, defendant must file all the documents in his possession and part along with the written statement. Then the third stage is Order 13, parties are allowed to file the documents all over again. Whatever is left out, please file. Then at the stage of 14, if you choose 14.5, you can still file documents. Still at the stage of a recording of evidence, Order 18, Rule 4 says that you can file any document along with the affidavit. So all these stages, basically, I personally feel we all must make an endeavor to make sure that the delay in litigation is cut short to the barest minimum. The aggrieved party must realize the benefits of his success as early as possible. And we can have a provision, perhaps I don't know, I'm not examined in detail, equivalent to a provision like in Consumer Protection Act, for instance. Now, in Consumer Protection Act, it applies to all consumers. There's a deficiency in service or defect in sale of goods, etc. Now, there, whatever the court, whether the commission court makes the order, there the court is known as State Commission and National Commission for the redressal of consumer disputes. Now, whatever the order is passed, if the order is not obeyed, the party disobeying the order is sent to jail. Although in civil law, for execution of money decrees and even other decrees,
Yes.
there are provisions where the executive court can send you behind the bars. But that sending you behind the bars is a very different from, for instance, I make an application that the judgment debtor is not intentionally not paying my money. He has the means to pay. He doesn't pay. He should be sent to civil prison. Suppose the court agrees with me. Then the consequence is, if I want him to send to be jail, I'll have to pay his subsistence money. I'll have to deposit the money. I'll have to bear all the expenses. So instead of realizing any money, I have to spend more money.
Yeah, that's true.
So now it's 1 o'clock. I think now, sorry.
Absolutely. I think so. We're well within our time, and I think we've covered some relevant questions as well. So once again, Mr. Kalra, thank you so much for joining in, and thank you so much for this insightful session. I'm sure everyone watching live has gained, both on our YouTube channel as well as the Zoom call, has gained from your experience, and we continue to hope to be guided by you. As a parting message, would you have something to say to the young lawyers who are just looking to join the bar and are sort of law students currently?
So we all learn from each other, and the whole life, this process goes on. So thank you very much for providing this opportunity of being with you. Thank you.
Sure. Thank you so much, sir. Thank you so much. Thank you so much, everyone, for joining in. Our next sessions will be day after, and on Friday, we'll be dealing with trade law and economics. And we'll be dealing with the jurisdiction of high courts, the original jurisdiction of high courts on Wednesday and Friday. There'll be other sessions, so do join me for that. Thank you so much, sir. It was a pleasure having you. Thank you.